the state disclosed what it had available to it at the time, and advancements in technology may change what was able to be extracted, but that's different than the state withholding information.
That was the state's reading of the affidavit. I think the other concern comes from the fact that back on March 18th, when the state was filing motions to preclude Lonnie Dworkin, the court had a discussion with the defendant about this, about whether or not she wanted to waive time to have time for her expert to do this. And at that time, the court asked her if there was any one device that she wanted to review, which was, from the defendant's own mouth, Charles Vallow's phone. So now we have a motion that was filed, mind you, 7 days after they received the affidavit from their expert. So they held off on disclosing that while we weren't in trial, and then in the middle of trial, filed it asking for information on numerous other devices that are in various other police agencies' possession. So, although I think ultimately, I mean, the big issue is clearly the state would object to any motion to dismiss. There is no exculpatory evidence. There's no even discussion of exculpatory evidence in Mr. Dworkin's statement or their very minimally fact-invasive motion, let alone any prosecutorial misconduct. But I think we're back to the issue of Mr. Dworkin and what he's going to be permitted to bring in or talk about at this point in this trial.
All right, did you want to argue that motion right now?
Not right now.
Well, when do you want to argue it?
Well, the main problem, do you want me to argue it right now?
I'm not asking you to, but I indicated when I read your motion that it does appear not to be any discovery violation, but that the state turned over the evidence that it had at the time, and advances in that software that maybe make more information available upon an extraction than was available when they did the extraction isn't a discovery violation. I'm looking at this as more of a discovery request for additional information, which at this point in the game, I'll allow you to do your discovery requests, but I don't know that any information that's discovered between now and the end of trial would be coming in because it's so late.
In reading that affidavit, I would agree with you that that was my initial thought as well. But the problem is that the problem that we have here is that that software was available and those things were available and they were not handed over from the state. They were never handed over from the state, and they've had that information for years. So that's why we filed that motion, is because of our expert was able to download the one device that we got, that he was able to see that the complete downloads were never given, that these are reports of downloads when we know that the state had available the entire complete extraction in the first place. They just didn't give us the entire extraction. They gave us the reports of the extractions, the ones that they wanted us to have. So those were available according to the technology. They just didn't give them to us on all of the devices. But we only have proof of it on one device because that's the only device that we were able to do in a timely manner.
All right. I want to clarify a little bit. They gave you the full extraction that was available to them at the time.
No, they pulled a report from the full extraction and gave us that. That's what they gave us.
State want to respond?
Your Honor, when you extract data from a device like a cell phone, it is put into a formula where it is not readable by anyone, which is why then you use the Cellbrite technology to basically parse that data into areas that we can read and view and review. So
is that what was given to the defense?
That is what was given to the defense, was the 2019 or 2020 version of the Cellbrite technology that was used to take that extraction and put it into a readable form so that you can enroll patients.
Your Honor, I would request that we can have a hearing on this so that I can bring in Lonnie Dworkin and he can explain that what they did not give us.
Well, just reading his affidavit is what they gave you is what they had available to them at the time. There's no affirmative duty for them to, every time a new software version comes out that makes maybe more data available, to rerun all the information.
We're not claiming that it is. We're claiming that they had a full extraction and they gave us a report of that full extraction instead of the full extraction on all the devices. It's not what only was available to them. They did have that available, they just didn't give it to us. It's cherry picking. It's
Okay.
cherry picking is what we got.
I don't read your own expert's affidavit the same way you're reading it, but,
That's why I'd like him to be able to come in and explain it. Can we set that up?
well, we can set that up at some point, but again, this is all late, and it's unlikely that anything that's happening would lead to him being allowed to testify, but maybe we'll do that this Friday or something. I don't know. We'll have to squeeze it in, but I'm not going to make the jury wait to do that.
Okay.